What happens if you're asked to play cricket in a basketball court? Or vice versa, what happens if you're asked to play basketball in a cricket ground? It's not comfortable, right? That's what exactly the realistic school of jurisprudence felt about all the other schools. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of lectures on jurisprudence, we were discussing about the different schools of jurisprudence. We have already understood many schools, like the analytical school said the sovereign will make the laws, you follow it, else you will be punished. Whereas the historical school said about all the customs and traditions as the source of law. The philosophical school believed in being just, fair and reasonable, whereas sociological school discussed about the manners, the commerce, the customs, the religion, etc. of our life. Now comes the realistic school. It says nothing is important. Law is practiced in the court hall. It is discussed between judges, parties and the advocates, etc. So that needs to be given very high importance when it comes to the sources of law. That's what they have believed. If they have believed, let us try understand this youngest school of jurisprudence in few slides. Let us start the discussion with few basic information. First thing first, let us try understand different names for this particular school. This school is called realistic school because it believes on the real-time experiences of the judges, advocates and the parties in a particular case inside the court hall. That is why it is called as realistic school. It is also called as American school because most of the scholars, jurists or philosophers on this particular thought are belonging from American school. I am not completely saying it is American school because there are few jurists who are coming from Europe, which is also called as Scandinavian school. There are few Swedish jurists also who gave thoughts, but for our syllabus I am focusing on American thoughts. It is also called as legal realism. It is also called as American realism or the modern theory. It is mostly called as modern theory because anything coming on this particular school, the thoughts are coming after the 18th century, and that is why it is quite young school, and that is why it is also called as modern school. So these are the different names that you can remember as far as this school is concerned. The second part is the famous scholars as far as the realistic school is concerned. The first one there is John Chipman Gray, who is also considered as the mental father of realistic school. Why so? Because he has given food for thoughts on this particular school. He was the first one to discuss this theory, and you can see the image of John Chipman Gray there. I don't have any independent slide. That is what you can remember about John Chipman Gray. He is the mental father of realistic school. The second one that we definitely are going to discuss about is Justice Oliver Wendell Holmes or W Holmes. He is called as the father of realistic approach. We have independent slide on Jerome Frank and Karl Llewellyn. Now these are the four important or famous scholars as far as realistic school is concerned. The third and last part of this slide, which are the points to be noted as far as this school is concerned. First and foremost, we need to remember that realistic schools believes about the thinking of judges, lawyers, and it gives high importance that how parties felt after a particular judgment. It also says that law is not predictable. It completely depends upon the different evidences that are coming in the court or the facts which are available inside the court. And it also says that law is not static. Like any other theory, it keeps on developing, and that is what they believe in. And they also say, just like analytical school, that look at law as is, not as it ought to be. That is one similarity between analytical and realistic school. The last part, that the Meaning of law in legal opinions of the judges, in the arguments, in the differences, in the agreements, in the dismissals, in the precedents, in the different doctrines. It is not anywhere else. In a nutshell, they say that aspects involved in the judicial decision making is the source of law. That is what they believe in. These are the few important aspects as far as realistic school is concerned. Oliver Wendell Holmes or W Holmes is the father of realistic school. He says that law is the experience and logic of judges. For him, what is law? It is the experience and logic of judges. That high importance he has given to judges. In his book or the essay, The Path of the Law, he says law is the thing that the courts do. It isn't simply what the courts state. So it is not just admin activity or execution. It is the thing that courts do. That much importance he gives to court as far as law is concerned. The second part that we need to remember about W Holmes is his badman theory of law. Now he says there are bad men in the society and these bad men are not worried about any morality or logic of law. For them, it is only the consequences if they are not following those available in the society. They are not absolutely concerned about the legal theories which are available in the society. They are only worried about the practical consequences like the imprisonment or the fine that they have to pay. Now he says these bad men are worried only about the consequences and these consequences are practically dealt in the court, and that is why law is the experience and logic of judges. That is his theory. The next jurist that we are discussing is Jerome Frank. Jerome Frank is well known for his book Law and the Modern Mind. It got a lot of appreciation as well as criticisms, and it was one of the jurisprudential bestseller of his period. Now he argued against those who said judges never make law. He said judges do make laws, or judges are the key participants in making the law. Another very important aspect we need to remember about Jerome Frank is he said certainty of law is a legal myth. Now what is certain? If you are adding 1 plus 1, that becomes 2. If you are doing it in India or USA or any part of the world, 1 plus 1 is equal to 2. That is certain because it is mathematics. But in law, you cannot say so. If you are giving same set of rules and same set of facts to two different judges, the judgment can go in two different ways. It completely depends on how parties have participated in the case, how advocates have interpreted the case, how judges have seen the case, what is the social background of that society, what is economical, political, all these aspects are influencing, and that is why certainty of law is a legal myth. He said there cannot be perfect law as such. It is always interpreted by different judges in different ways in different times as per the requirement, and it also involves psychological aspects of that particular case. Remember, when we are discussing about realistic school, we should also keep penology, criminology, all of these subjects because the theories also came along with these schools. Jerome Frank also said, or rather urged to judges and legal scholars to acknowledge openly if there are any gaps or uncertainties available in law, and he asked them to think of law practically as a tool for human betterment. That is what he urged. The last jurist that we are discussing here is Karl Llewellyn. While the previous two worked as judges, Karl Llewellyn worked as law teacher, and he is known for his work The Bramble Bush on Our Law and Its Study. He said, behind decisions stand judges. Judges are men. As men, they have human backgrounds. Now, that is the importance that he has given to judges. Judges are behind every single judgments, and they are also human beings, and they will have human backgrounds, and that is how they interpret and come to a conclusion. Now he draws a beautiful process. He says law is dealing with disputes, and the disputes need to be dealt reasonably, and the disputes are dealt by the concerned people, that is judges, lawyers, police, jailers, etc. And all of them are trying to solve the dispute, and this can be dealt dynamically. Different people can see it in a different way. It is not static. It can be seen in different dynamics to serve the social needs. Now he says, why are we dealing with law? It is to serve the social need of the human being. And he also goes along with the sociological jurisprudence in a certain manner, and then he says judges have greater freedom in studying individuals as well as at arriving to conclusions. Now judges, being the part of society, they know what is the economical condition, what is the political background, all of that, and with that knowledge judges will really conclude the case as per the requirement. That is what he says. The last part, the criticisms against the realistic school. The first one, less importance to law. If you see in analytical school, sovereign has given lot of importance and lawmaking process was given lot of importance, whereas realistic school has completely ignored it and the same been criticized. The second one, more importance to court hall and not judicial systems. The legal realism has given high importance to court hall alone, and it completely neglected the judicial system, so that is also been criticized. The third one, it got criticized for ignoring the formal or conceptual approach of law. All this time there was a way of looking at law, and by 18th-19th century the realism school completely looked law as a different aspect, and for that it got criticized. The fourth one, it gave more importance to emotions and ignored logic. While discussing about the parties how felt, it completely ignored the logic part, so that is being criticized. Fifth one, it gave unnecessary importance to psychological aspects, that is what other schools felt. The sixth one, it gave unnecessary importance to the convictions of the judges and the judicial system. It doesn't give any importance to the lawmakers. For that also it got criticized. Seventh one, there was less importance to legal terminologies, and the same can lead to uncertainties. Now if different judges start seeing at things in different way, it can lead to uncertainty, and that is what felt by other jurists, and they have criticized for the same. The last one, if mere judgment becomes law. Now people will always try to go for a new judgment in favor of them. There is no importance to precedent also, because every judge can look at it in a different way, so that way no case can be predictable. That will do lot of cumbersome to the legal system in a whole, and for that the legal realism or the realistic school got criticized.
Good and bad, it's everywhere. It's out there as well as within us. We need to be as good as possible. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.